Hi everyone, this is CA Harsha Buddala. Today we are going to discuss one of the important GST judgments pronounced in the recent times. Now, why this judgment is very important? Because the Honorable Madras High Court in this judgment had completely quashed the notice and the order passed under section 74 of the CGST Act. They didn't even remand it back, they have completely quashed it. So that is why this is important. Now, this judgment, the parties involved were Niyamo Enterprises Solutions Private Limited. They are the petitioners, and the respondent were the commercial tax officers of the Tamil Nadu state government. Now, these are the petitioners and the respondent of this case. Now, before proceeding into the case detailedly, I just quickly give you an overview about issuing notices under issuing notices under GST. Now, issuing notices under in GST, whenever the tax is not paid or the tax is short paid, the department can issue show cause notices. Show cause notice can be issued under section 73 and they can issue notice under section 74 as well. Now, why two sections are there? Now, if you observe the notice under section 73, the notice under section 74, it has a specific purpose. 74 notice can be issued only when there is fraud involved or willful misstatement or suppression of fact. Whenever these three elements, whenever there is any no payment or short payment of tax due to fraud, due to willful misstatement, due to suppression of fact, then the department can issue notice under section 74. In any other case, they can issue notice under section 73, other than fraud, willful misstatement and suppression of fact. Now, in the current case, the notice was issued under section 74. Now, what is the other important point we have to consider was the time limits. Now, the time limit to issue the order or the factually speaking order, the time limit to issue order under section 74 was they are having 5 years time from the due date of filing of annual return. In GST will file annual return. From that annual return, they will be having 5 years of time to pass an order under section 74. Whereas it comes to 73, they are having only 3 years time, not 5 years. Now, there was an extended time limit benefit in case of section 74. Now, actually what is happening was in many cases the GST department, whenever the time limit under section 73 got expired, whenever the time limit to issue notice under 73 got expired, now they are issuing notice under section 74 without establishing that there is fraud, willful misstatement and suppression of fact. They are simply speaking, they are taking the advantage of the extended time limit benefit by issuing notices under section 74. Say like they decide to issue notice under section 73, but the time limit under section 73 got expired. Immediately they are going and exploring the option of 74, issuing notice under 74, even though there is no any element of fraud, willful misstatement and suppression of fact. This is the problem. Now here, in the instant case also, the Niyamo Enterprises Solutions Private Limited, they have been issued show cause notice for the financial year 18-19 to 22-23. Okay, and the petitioner in this case had failed to respond to the show cause notices, and immediately the department had passed the order confirming the demand they have quoted in the show cause notice. Now, challenging or aggrieved by the notice and the order, the petitioner had approached the Honorable Madras High Court, Madurai bench. Okay, now the contention, before going into the court analysis, I just quickly want to highlight the contention of the petitioner. The contention of the petitioner was, you have issued notice under section 74, but you have merely alleged that I have involved in fraud, willful misstatement and suppression of fact. You didn't substantiate or you didn't provide any material evidence that how you are saying that how I am involved in fraud, willful misstatement and suppression of fact. Your show cause notice is lacking these details. If your show cause notice is lacking in these details, how can I now counter that? How can I save myself? How can I make my representations against your points of fraud, willful misstatement and suppression of fact? So the show cause notice is not providing all these details. They have simply alleged. This is what the main contention of the petitioner. Now let us see the court analysis, what court had said. Now the court had said that it is not enough to merely impute the offend conducting to the assessee. you can't simply attribute the offend conduct to the assessee. You can't simply attribute to him. The show cause notice itself must disclose the entire material on which the proper notice has arrived at such a conclusion. Now you have to, along with the show cause notice, you have to give all the material evidences that how you are saying that there is a fraud, no willful misstatement or suppression of fact. All these details should be provided in the. So this is what the major point the court had also highlighted. Now the provision, they also said that the provision itself stipulated that such a situation must have been by reason of fraud or any willful misstatement or suppression of fact to evade tax. So the show cause notice itself should have to prove that. So which is lacking in this case. Now the court had also referred the Supreme Court, Honorable Supreme Court High Court judgment, Honorable Supreme Court judgment in the case of Tamil Nadu State Housing Board versus Collector of Central Excise, where it was said that extension of limitation period. Now if you observe, under 73, your time limit was only 3 years. Now that limitation period was extended for 5 years in case of 74. Now what the Honorable Supreme Court in this judgment had said that the extension of limitation period should have to be constructed very strictly. It means that whenever you are extending the time period under section 74, whatever the section is saying, that has to be satisfied. You can't deviate from the section. Now your facts or your scenario is not properly fitting in the section, then you can't issue or you can't take the benefit of the extended time period, is what the Honorable Supreme Court had said in this case of Tamil Nadu Housing Board versus Collector of Central Excise. Not only this, the Honorable Madras High Court had also referred Safecon Life Sciences Private Limited, in which it was held that proceedings under section 74 could not have been initiated against the petitioner since the authorities have neither recorded any findings of fraud nor willful misstatement or suppression of fact to evade payment of tax. Now here the authorities have not recorded any findings of fraud. Then how can you issue notice under section 74? This is already settled by the Allahabad High Court in the Safecon Life Sciences Private Limited. All these judgments were analyzed by the Honorable Madras High Court in this judgment. And also they have said that presence of one or all the three elements. What are that one or three, all the three elements? That is this no fraud, willful misstatement and suppression of fact is essential to take action and against us, to take action or to initiate action under 74 of the CGST Act. And they have also referred the Honorable Judge of the no particular case had referred SS Communications versus Deputy State Tax Officer case, in which they have referred that section 74 of the, in terms of section 74 of the Act, fraud, willful misstatement or suppression of fact to evade tax would constitute the jurisdictional fact. A very, very important word used in this judgment, that is jurisdictional fact. Now you are getting power to issue notice under section 74 because of the fact there is a fraud, willful misstatement and suppression of fact. If I remove this aspect of fraud, willful misstatement and suppression of fact, you don't even have the jurisdiction, you don't even have the power to resort section 74. 74 will comes only in a scenario where it is a jurisdictional fact. The power you are getting is through a factual scenario where there is any involvement of fraud, willful misstatement or suppression of fact. If that is missing, you don't have any power to issue notice under section 74. Constitute the jurisdictional fact for invoking extended period of limitation. That is what happening now nowadays. They are taking the limitation, they are taking the extended limitation benefit given under section 74 without the jurisdictional fact. Without the jurisdictional fact, they are extending. And failure to record the existence of the above jurisdictional fact while invoking the extended period under section 74. So this was given in SS Communications versus the Deputy State Tax Officer. Okay, so this judgment has been referred by the Honorable Judge in this judgment. And not only this, they have also referred one of the department circular in which they have stated that section 74 cannot be invoked merely on account of non-payment of GST without specific element of fraud or willful misstatement or suppression of fact. Therefore, only in cases where the investigation indicates that there is a material evidence of fraud, willful misstatement or suppression of fact, then only section 74 can be invoked. This is what their own circular, department own circular is saying. So now what the learned counsel of the government or the on behalf of the respondent had submitted, that they have quoted one writ petition number 28,502 of 2022 dated 28 Jan 2025. In this judgment, what happened was, this was the judgment quoted by the counsel on behalf of the respondent to counter what the court intention was. Now, in this judgment, whatever in this writ petition, whatever they have referred, what it was said was the petitioner or the taxpayer in this case, is supposed to take registration, but they have not taken registration. So whenever department issued the notice or whenever department initiated the proceedings, they have started paying the tax. So I can show you that the petitioner had remitted the tax that he is liable to pay. Even though such action is claimed to be voluntary payment to the petitioner, it should be seen that the petitioner had attempted to avoid payment of tax. The conduct of the petitioner to avoid tax will also fall under suppression and fraudulent activities envisaged under section 74. This is what the learned judge of this court, that is the same Madras High Court, had given in one judgment. So the same court had given in some other in this writ petition case, stating that the conduct to avoid the tax itself is a sufficient ground to initiate proceedings under section 74. Now look here, this is again an important part. Now the honorable judge of this judgment, that is Niyama Enterprise Solutions Private Limited versus the Commercial Tax Department of the Tamil Nadu. Now what the judge had pointed out, had highlighted was, he had beautifully counted that. They have said that there is no reference to the earlier order dated 20th September 2024. Now what happened was, this SS communication judgment is there. Now this SS communication judgment was issued in the year 2024. Now whatever the writ petition which the opposite counsel, that is the counsel of the respondent, had referred was passed or pronounced in the year 2025. Now what is this writ petition which the respondent counsel want to rely was a subsequent decision. I mean to say, this writ petition judgment is a subsequent decision which the respondent is relying. This is a subsequent decision. Now what they are saying was, there is no, whenever a subsequent decision is being given by the same court, if they are deviating from the earlier judgment, they have to bring that earlier judgment and they have to explain why they are deviating. So what they have said was, what the honorable judge of this judgment had highlighted was, there is no reference to the earlier order dated. That is SS communication, they didn't refer because it was already a settled precedent. By the time the above said judgment was passed, the SS communication judgment was already a settled precedent. No, that was not referred in the above said judgment. I mean the judgment which the respondent counsel is referring. And also there is no reference to the circular. So considering these two factors, and also the judge had said that, in my view, non-payment or short payment of tax or even evasion of tax by itself is not sufficient. There must be a reason of the element specifically set out in section 74. Now, whatever the judgment of this court itself that has been referred by the opposite counsel has been set aside or has been countered by the honorable court by stating that there is no reference to the earlier order, that is SS communication. They didn't stated why they are deviating from the SS communication, and also they didn't refer the circular. For these reasons, I am not accepting or aligning with the view that was given in that judgment. And what they have said was, when a subsequent decisions depart from the earlier approach, the judge concerned will have to not only make a reference to the earlier precedent but also give reasons for such departure. No, any such thing was not there in this judgment. In this judgment, such thing was not there. Okay, this is what one important point. And again the counsel for the respondent, they have also referred another judge of another judgment pronounced by this court in the writ petition number 3458 of 2024. So in this what happened was similar kind of case where there is no sufficient grounds were there, no sufficient grounds for section 74, but the court had remanded back. They didn't quash it. They have remanded back. So that judgment the counsel for the respondent had cited. Okay. Now requesting for remanded back instead of quashing. Now before proceeding about the what court had said, I just want to highlight the difference between remand back and the quashing an order. See, when remand back can be done and when quashing will be done, no? Whenever there is any procedural errors, or whenever your job, whatever your job is that you have not done in a fair way or you have not done your job properly, then what I can say was I can ask you to go back, do it properly and come back. This is what I can say. Whenever you are supposed to do, you have power to do, and you have not done it properly, or whenever there is any procedural errors. But quashing is altogether a different thing where you don't even have the power to do it. Now, whenever you don't even have any power to do it and you are doing it, how can I say that? How can I give a remand back and ask you to correct it and come back? So the proper thing in quashing was you should not have to come back. You don't even have the power to do it, but you have done it. So I will completely quash the order. So this is the difference between quashing and remanding back. Remanding back, simply speaking, you have not done it properly. I will remand you back. You do it properly and you do your responsibility properly. Now in quashing, you don't even have the power to do it. So this is what the difference between remanding back and quashing. Okay. Now after this judgment was cited, this writ petition number 3458 of 2021 was cited by the counsel of the respondent. Now the court had said that when jurisdictional facts are absent, the order has to be set aside and the court will have to stop at that. Their absence would completely undermine the very foundation itself. In this scenario, the jurisdictional facts itself are missing. Now, what is the jurisdictional facts? The jurisdictional facts are like 74 notice can be issued only when there is any fraud. 74 notice can be issued only when there is any fraud, willful misstatement and suppression of facts. If these three factual things are missing, how can you issue notice under section 74? This jurisdictional fact is missing, thereby notice under section 74 cannot be initiated. So how can you ask for remand back? When you don't have the power to issue, how can you ask for remand back? If you are having power and if you have done procedural errors, I would have allowed remanded back. You don't have the power, but even then you have acted, I will not give you remand back, I will completely quash it. Okay, so this is what an order of remanded cannot be made mechanically. In such situation, the question of making a remand does not arise. When their absence would completely undermine the very foundation itself. Whenever the jurisdictional facts are absent, it would completely undermine the very foundation itself. In such cases, the question of making a remand does not arise. Okay, and also they have highlighted another important point that the show cause notices issued under 74 are using the word determined. Okay, so actually the section 74 subsection 1 is talking about specifying. So what court had said was there is a ocean of difference between the word specifying and determining. The word determined found in the show cause notice cannot be construed as specified. So what they have said was the show cause notice in this case, by employing the expression determination betray the element of predetermination on the part of the authority. No, the show cause notice issued in this case had directly used the word determination instead of specifying. Now what court had said was, you using the word determination is clearly exposing the element of predetermination on your part. You have already decided. So you are not specifying, you are determining. which is not correct. There is a lot of difference between the word specifying and determining is what the court had said. This is what one new point which the court had highlighted. And finally, what they said was, since the show cause notice as well as the impugned orders themselves do not charge the writ petitioner with fraud or willful misstatement or suppression of fact, they stand quashed. Section 74 of the Act cannot have been invoked against the petitioner. This is what the final point given by the court. So, being now final crux was, whenever 74 notice was issued, the notice should have to clearly state or should have to provide all the material evidence that how they are saying that the petitioner was that the taxpayer was involved in fraud, willful misstatement and suppression of fact. If that points are missing, the notice itself can be quashed and the notice itself is lacking the jurisdictional power. This is what the final take of this judgment. Thank you.